Good afternoon to you. We will continue with the Constitution. We have completed state judiciary, appointment of judges, removal of judges, conditions of service of judges, and what are their perquisites, what are their independence of judiciary. All these things we have seen. Now we will look into tribunals. The next topic is tribunals. It's a new topic, important from academic as well as examination point of view. One or two questions, very important points. Number one, there is no provision in the Constitution, in the original Constitution, for tribunals. Point number one. Then now it was added through 42nd Amendment Act 1976. Added a new part 14A. What is the part number? 14A, which added 42nd Amendment Act 1976 on the topic tribunals. This part has only 2 articles, very little articles, only 2. What are those? 323A, which deals with administrative tribunals, 323B, which deals with tribunals for other matters. So, 42nd Amendment Act 1976, Part 14A on tribunals, 2 articles only. 323A dealing with administrative tribunals, 323B dealing with tribunals for other matters. First, let us come to administrative tribunals. Article 323A authorizes the Parliament, empowers the Parliament to set up administrative tribunals for adjudication of disputes regarding recruitment and conditions of service of persons appointed to public services of the central government, state governments, local bodies, public corporations, and public authorities. Remember, under this article, Parliament can take out of the adjudication of disputes relating to service matters from the civil courts and the high courts and place them with the administrative tribunal. That is the original intention. That is, the adjudication of disputes with regard to the service matters of the central government, state government, public authorities, etc. were then resolved by the High Court. That responsibility was given to the High Court. What Mrs. Gandhi did is, to lower the burden of the High Court, she wanted to carve out these administrative disputes and entrust this to a separate tribunal under Article 323A. That is how the administrative tribunals was sought to be established. Under Article 323A, Parliament accordingly enacted Administrative Tribunals Act of 1985. What is the Act number? Administrative Tribunal Act of 1985. Under this Act, the central government will set up one central administrative tribunal and also the state administrative tribunals. What was the intention? Intention was to provide speedy justice, and inexpensive justice to the public servants. This was the intention. Because whatever amount they are spending in the High Court, she thought it can be very less can be spent in the CAT, and those expenses can be saved. Now, first let us come to Central Administrative Tribunal. The Central Administrative Tribunal was set up in 1985. When? 1985. The principal bench at Delhi and additional benches in different states. At present there are 17 regular benches, of which 15 operate at the principal seats of High Court and the remaining 2 at Jaipur and Lucknow. These benches also hold what is called circuit sittings at other seats of High Court. For example, there are 21 circuit cities in 9 benches of CAT. Now, the CAT has the original jurisdiction with regard to recruitment and all service matters of public servants, covering all India services, central field service, civil posts under the center, and civilian employees of defense services, who are all governed. Kindly go through carefully. All India services, central field service, civil posts under the center, and the civilian employees of defense services. These categories of staff are governed by the jurisdiction of CAT. Now, who are all excluded? Remember, the members of defense forces, staff of Supreme Court, staff of Parliament are not covered. 3 group of people not covered. Parliament Secretariat, Armed Forces, that is Defense Forces, and the Supreme Court officers and officials. They are not covered by CAT. Now, CAT is a multi-membered body consisting of 1 chairman and members. Originally, there was a post of vice chairman, but in 2006, the provision of vice chairman was removed under Administrative Tribunal Amendment Act of 2006. So, at present, there is only 1 chairman in the CAT, and the sanctioned strength of members is only 65, drawn from both administrative and judicial stream. Now, chairman and members are appointed by President. Chairman holds office for 5 years or 65 years of age, whichever is earlier. The members hold their office for 5 years or 62 years, whichever is earlier. Now, the members are appointed on the recommendation of High Power Selection Committee, chaired by a sitting judge of Supreme Court, who is nominated by Chief Justice of India. After getting the concurrence of the Chief Justice of India, ACC, that is Cabinet Committee on Appointment, approves the formal appointment. Now remember, the CAT is not bound by the procedure given in Code of Civil Procedure 1908. It decides the cases primarily on the principles of natural justice. It adopts very flexible approach. The charges are very nominal, 50 rupees per application. The applicant can appear in person to defend the case, or he can engage a lawyer also. The original intention of setting up of administrative tribunal was that these tribunals would reduce the burden of the work of the high courts, because the appeal against the orders of CAT lies only with the Supreme Court. So, one tier was cut down. However, in Chandrakumar versus Union of India 1997 case, Supreme Court declared that the restrictions on the jurisdiction of the High Court as unconstitutional, because judicial review by the High Court is a basic structure given in the Constitution itself. Accordingly, now it is not possible for anyone, for any aggrieved person, to go to the Supreme Court directly against the orders of CAT without first going to the High Court. So, this is the position with regard to Central Administrative Tribunal. Very important from examination. You will get 2 or 3 questions. Next, we are coming to State Administrative Tribunal. The State Administrative Tribunal Act of 1985. Which Act? 1985. Empowers the central government, even though the name is state, remember with whom the powers lie? Central government. To establish State Administrative Tribunal on the request of the concerned state governments. So far, State Administrative Tribunals were set up in 9 states of Andhra Pradesh, Himachal Pradesh, Odisha, Karnataka, Madhya Pradesh, Maharashtra, Tamil Nadu, West Bengal and Kerala. However, Madhya Pradesh, Tamil Nadu, Himachal Pradesh tribunals have been since abolished. Subsequently, Himachal Pradesh re-established the State Administrative Tribunal. Tamil Nadu has requested for re-establishment of tribunal. Similarly, Haryana wanted to re-establish State Administrative Tribunal, whereas Odisha wanted to abolish. This is the present situation. The SAT, that is State Administrative Tribunal, has original jurisdiction with regard to recruitment and service matters of state government employees. On whom? State government employees. The chairman and members of State Administrative Tribunal are appointed by President after consulting Governor. These are very nice points, very nuances. You have to be very careful, because the appointment, normally we will be tempted to tick mark Governor, what is known as the appointment is made by the Governor. No, the appointment is made by the President after consulting Governor. We will be tempted to note Chief Justice. No. So, President appoints after consulting Governor. Which one? State Administrative Tribunal, Chairman and members. Now, there is also a provision for Joint Administrative Tribunal, JAT, for 2 or more states. For 2 or more states, there can be a Joint Administrative Tribunal to exercise jurisdiction and powers of such states. If 2, then both the states, they exercise the powers. Similar in the case of State Administrative Tribunal, the chairman and members of Joint Administrative Tribunal are also appointed by President of India after consulting the governors of the state. Remember, who is consulted? Consulting governors of the state. Now, tribunals are other matters. We have up to under Article 323A, we have seen administrative tribunals. Now, tribunal for dealing with other matters that is other than administrative matters. This is Article 323B. Under this article, both the Parliament and state legislatures can set up tribunal for adjudication of disputes on certain matters. What are those matters? Number 1, taxation. Number 2, foreign exchange, including export and import. Number 3, industrial and labor. Number 4, land reforms. Number 5, sealing on urban property. Number 6, elections of parliament and state legislatures. Number 7, foodstuffs. Number 8, rent and tenancy rights. Remember, the rent and tenancy rights were added through 75th Amendment Act 1993. Very important point, a small point that you should remember. Now, just to compare Article 323A, that is, which set up the administrative tribunal, and Article 323P, which set up the set up tribunals other than administrative matters. Compare these two. Very simple. Article 323A deals with setting up of tribunals for public service matters only. On the other hand, 323B deals with tribunals of other matters. What are the other matters? 7 items, 8 items, I have already told you. Similarly, 323A is the prerogative of the Parliament. That is, only Parliament can establish the administrative tribunals, both Central Administrative Tribunal, State Administrative Tribunal, Joint Administrative Tribunal, all these things who can establish? Only Parliament. Whereas 323B empowers both the Parliament and state legislatures to set up their tribunals on matters which are falling under their legislative competence given in Schedule 7. Where the legislative competence is given? Schedule 7. Then thirdly, under Article 323A, there is only one tribunal for the central government and one for each state or 2 or more states. This can be set up. There is no question of hierarchy of tribunals under Article 323A. On the other hand, under Article 323B, the hierarchy of tribunals can be created. That is possible because there are 8 matters are there. So, hierarchy can be created. Now, as said earlier, in Chandra Kumar case of 1997, Supreme Court declared the provision of both these articles which exclude High Court jurisdiction and Supreme Court jurisdiction as unconstitutional. So remember, these excluding the High Court jurisdiction has been made declared unconstitutional by the Supreme Court. Now you can approach the Supreme Court only after exhausting the channel of approaching the High Court. So with this we end the tribunals part, 323A and 323B. Tomorrow we will see district courts and both for civil side and criminal side, district judge for civil matters, sessions judge for criminal matters. All these things we will see tomorrow. Thank you. Thank you.